case briefs, and so much more. LSData's got what you're looking for.
In the early 2000s, Beanstalk Group Inc. found itself at the heart of a lawsuit against two automobile corporations, AM General and General Motors, GM. The crux of the verdict, a precedent-setting decision by the United States Court of Appeals for the Seventh Circuit, lay in the unique interpretation of contract law, focusing on the fact that plain meaning usually governs unless the outcome would be absurd or counter to the engaging party's intentions. The conflict began swiftly after AM General, a manufacturer of military and civil vehicles, sold their Hummer trademark to General Motors in 1999. Beanstalk, renowned for negotiating licensing deals for its clients, contended that their contract with AM General entitled them to 35% of the gross receipts from any such licensing deals. They boldly claimed that the sale of the trademark to GM was essentially a licensing deal, and thus they were legally guaranteed a fraction of the profits. However, their argument did not hold up in the lower courts. The case was peremptorily dismissed, with the district judge concluding that Beanstalk's interpretation of the contract was unreasonable. But Beanstalk, believing in the strength of their argument, decided to appeal the decision. Their appeal eventually led them to the United States Court of Appeals for the Seventh Circuit. The majority opinion, orchestrated by Circuit Judge Posner, elaborated that Beanstalk was merely serving as AM General's agent, tasked with obtaining licenses for the Hummer trademark. The agreement explicitly stated that while Beanstalk would technically receive the payments on behalf of AM General, the latter retained the right to veto any potential licenses. The court emphasized that the crucial element in contract law is the plain, written language of the agreement. While acknowledging that consideration might be given to potential absurd outcomes, the overall contract and its context, the court held that judges could use their personal experiences when interpreting contracts. Even the dissenting opinion suggested that such cases warranted further exploration. However, they unanimously agreed that it was highly unlikely that the parties ever anticipated that Beanstalk would receive a commission on the entirety of the business sale, including the trademark. In the end, after careful deliberation, the court ultimately upheld the original decision. The dismissal of Beanstalk's claim was affirmed. The resounding affirmation continues to showcase the complex dynamics of contract law, especially in the intricate intersection of corporate deals and brand trademarks.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of climb.